Hello, everyone, and welcome to the Searle Court podcast. I'm Sophia Hurst, and I'm here with Gregor Hogan.
Hello there from Self-Isolation.
And we're going to be spending the next 15 minutes or so discussing some of the issues that arise in the current crisis of COVID-19 from the perspective of trusts and estates practitioners, hopefully offering some useful thoughts and our perspective on the kinds of issues that have been arising. So, Gregor, do you want to kick us off?
Yes, of course. Well, I think the first issue that's really arisen for practitioners in this area is a lot of clients urgently seeking to execute new wills. But of course, and we'll turn to the issues regarding execution of wills, I think, later on in our discussion. But the first step is taking instructions. Ordinarily, a solicitor would want to either visit the testator or testatrix in their home and take instructions, or invite them into the office. However, that's clearly going to be an issue when we're in the current lockdown. But even beyond lockdown, when, for example, the testator is particularly vulnerable or is in the shielded category, which, as I understand it, is sort of super duper social distancing. So your options, therefore, then seem to be whether you can take instructions via telephone or via video conferencing. However, I think those give rise to a number of issues. The first of which is that the solicitor plays a key role in determining whether or not, in his or her view, the testator has capacity at the time they execute the will. And there's a real question in my mind as to whether or not a solicitor really would be able to make that assessment. And of course, that's of particular importance. I don't know whether, Sophia, you had any thoughts as to whether or not a solicitor would be able to make that sort of assessment via video link.
Absolutely. I think this is, as you say, in the current climate, it's time to sort of start thinking more creatively and actually using the video to be something that offers opportunity. For example, you can take a recording of, obviously with the client's consent, of that conference, and you'll have a really good record there of the steps that have been taken in order to assess capacity, which may be important because in current circumstances, it may be particularly difficult to comply with the golden rule and also get the opinion of a medical practitioner.
Indeed. I mean, of course, that was an issue long before COVID-19. I know a number of practitioners were basically saying the golden rule was almost redundant because medical practitioners, for obvious reasons, weren't willing to run the risk of being hauled into court to recall the advice that they'd given at the time of execution. It seemed to me that another issue that arises in relation to the remote taking of instructions for wills is a possibility for undue influence. Good practice would suggest that when an solicitor is normally taking instructions from a testator, they would do so in private with those who attend with them at the solicitor's offices sitting in another room, in order that the solicitor can really assess whether or not the instructions will be given freely and without undue pressure. However, without sort of casting up sort of rather strange imagery, one can never be sure in a video conference of who's lurking in the background. It may also be that a vulnerable testator is living in the same household as the undue influencer. And so I think there's real issues as to whether or not a solicitor can be satisfied as to whether or not the instructions are being freely given. I think there might be some Law Society guidance on this, in particular in relation to urgent instructions.
Yes, and I think the point that you raised about undue influence is a good one. As far as I'm aware, current guidance from the Law Society is that whilst we have to be alert to these sorts of issues, if the circumstances are urgent, then best practice is to complete the will, obviously make full notes of the meeting and any discussions that happen. But even if capacity is questionable or that there's a suspicion of undue influence, then get it done. And then once circumstances permit, make arrangements to see the client again to confirm those instructions in private and arrange a capacity assessment if needed once lockdown and so on has been lifted. And if necessary, re-sign the will.
I mean, I think in general, there may be a question here about whether or not you have concerns about undue influence or a lack of capacity. Where during the COVID-19 crisis, instructions have been given on a very urgent basis, say, for example, if somebody's in the shielded category or they're unwell, it may well be appropriate after the crisis is over to reach out to the client and seek confirmation that their instructions still stand, because the decisions made in a pressurized environment of ill health or risk of ill health may be quite different from those which would be given once that risk is passed.
Absolutely.
And of course, once the instructions for the will have been taken, there then comes the tricky question of the execution of the will, which has given rise to quite a lot of commentary amongst practitioners recently.
Yes, who knew that Section 9 of the Wills Act was going to be in the mainstream media, attracting so much attention, but here we are, we live in strange times. So, as I'm sure all of our listeners will be aware, the key question on executing wills under Section 9 is that it has to be signed by the testator or at his or her direction in the presence of at least two witnesses at the same time. And that gives rise to obvious concerns with social distancing and social isolation. As for social distancing, I think the guidance is pretty clear. We can stay 2 meters away from each other, and it is possible to physically witness a will in those circumstances, obviously taking relevant precautions. You hear anecdotally about people wearing gloves, making sure that they've got their own pens. I don't know, Gregor, if you've had any stories on that.
Yes, I've heard a story of garden chairs being placed at 2 meter intervals apart from each other on a patio, and solicitor bringing with them their own printer, instructions being confirmed, and then the will being passed round between gloved hands and signed. There's also reports from the BBC News website of people signing wills on car bonnets. Neighbours can often be a very good source of witnesses in these circumstances, provided, of course, that they don't receive any benefit under the will or aren't going to act as an executor. But of course, the question has arisen as to whether or not video conferencing might be an alternative to these kind of creative solutions. As far as I'm aware, there was a report by the Law Commission a few years ago which suggested that is not considered a current possibility.
Yes, so the Law Commission looked at all manner of electronic signatures and so on in its recent consultation, which culminated in a report that was published in September. And although concluding on the current case law that electronic signatures were valid, their conclusion as to Section 9 was that witnessing could not extend to witnessing via video conferencing because presence has been held to involve physical presence. Although noting and caveating that many of the cases which refer to the requirement for physical presence were of such a time that there was really no other viable alternative. They were pre-internet cases. But nevertheless, the current view is that although there's possibly some room for argument on the case law, the current view seems to be that video conferencing is not going to be sufficient to satisfy the requirement for witnessing, and so it would require legislative intervention.
And it's interesting, when I was considering this point, I'm going back to my Scottish cultural, albeit not Scottish legal roots, and I discovered some guidance from the Law Society in Scotland, which suggested that witnessing of wills via video conferencing would be sufficient. However, digging into the matter a bit further, it appears that the relevant legislation in Scotland, which is the requirement of Writing Scotland Act 1995, doesn't contain that same requirement of witnessing, quote, in the presence of, end quote, the testator. So I'm not sure whether any real assistance can be drawn from that for solicitors in England and Wales, but it did occur to me as to whether or not there might be some innovative techniques being deployed in other common law jurisdictions. Are you aware of anything?
Yes, interestingly, although the UK government has said that it doesn't have plans to introduce any legislation, there are a few other jurisdictions that we've come across that have taken emergency measures. One example that I think is really interesting is the Dubai International Financial Centre Courts, the DIFC offshore jurisdiction. And on the 24th of March, they introduced new legislation for their Wills Service Centre. And it's an entirely new system for registering wills via video conferencing. And the way it works is that you book an appointment with the wills registrar. You upload to the system an approved draft will and confirmation of ID documents. And then at your appointment, everybody joins the video conference. The will registrar satisfies his or herself that the parties present are who they say they are. And everybody gets sent the draft will. They affix their electronic signature and re-upload back onto the system. And if that is all done to the satisfaction of the registrar, then that is registered as a valid DIFC will. And there's no time restriction on that. That's just a new innovation that they have done in response to the crisis, which I think is really interesting and a great blueprint of how to use the technology available. Another hot off the press development that I've heard of in Jersey. On the 22nd of April, Jersey introduced regulations to the state's parliament in order to relax what I understand to be quite similar requirements to the UK requirements, that a will must be witnessed by two witnesses physically present when the will is signed. They've introduced legislation to relax that and to allow for video conferencing. Interestingly, expressly on the basis that the Jersey Parliament considers witnesses are presenting a public health risk by placing themselves near to others outside of their family unit. But, and sort of in line with what you were saying earlier, Gregor, the guidance insists that lawyers should take steps afterwards to make sure that any client that makes a legal document using this new legislation isn't under duress and has appropriate mental capacity. And the legislation is only temporary in Jersey, so it's going to expire on the 30th of September unless extended. But I think both interesting examples of ways that perhaps the UK government could be doing more to help with this particular issue. Gregor, have you got any further insights?
Yes, there seems to be developments in New Zealand and parts of Australia as well. So I've come across a piece of emergency legislation in New Zealand which suggests that ordinarily the position is, again, like in England, witnessing would have to take place in the presence of the testator. However, they have introduced emergency legislation which allows that to be made, that witnessing to take place via audio-visual link, but only if there's an epidemic notice in force in the area where one of the witnesses or both of the witnesses are located. That appears to only be in force from April the 17th to when the emergency corona legislation in New Zealand expires. Similarly, in Queensland, there has been some guidance issued which effectively allows a will to be executed in the presence of two witnesses, being in the presence of the testator audio-visually via conference, or in the place actually of only one witness via audio-visual conference. Again, that only lasts until the 30th of September this year. So quite specific corona-related responses, which I don't think really deal with the broader issues we've been discussing as to whether or not the physical presence requirement is still fit for purpose in the modern age, but certainly some guidance from which the government in the UK could draw some inspiration in creating a more flexible response to witnessing of wills in this period.
Absolutely. Unfortunately, it doesn't seem that there are any plans for any such legislation, and so we fall back on the case law. There's an old case of Caston Day from 1781, which is having its vogue. In that case, the testator was located in a carriage outside the solicitor's office, but was in the line of sight through the window of the solicitor's office, where the witnesses were signing in the office. And in that case, that was to satisfy the requirement of presence. So this case is being referred to and relied on when considering clients that are in full, as we said, super isolation. How do we satisfy witnesses in those cases who they're stated through a window, if that's the only way of getting the job done?
Interesting. I mean, I think anyone with any experience of the probate registry would acknowledge that the kind of online electronic wizardry of appointments being used in the DIFC is probably some way off in the UK, but I think this whole experience has certainly brought to the fore the need for the government to give real consideration to the Law Commission's recent report on all things testamentary dispositions and succession. Moving on then, I think another issue that I've seen practitioners discussing is the roles of LPAs and deputyships in the current climate and how those might work in practice. Of course, where you have an existing LPA which has been registered, the first question which might arise is if it's a joint LPA, is how can that be exercised, the powers under that LPA be exercised when everyone is socially distanced and locked down in their homes? Now, the first question would seem to be whether the attorneys can act jointly and severally. If they can, that seems to offer quite a simple solution. If the decision that needs to be taken is one that cannot be done at appropriate social distancing levels. But another question is, what happens if you have an LPA which hasn't been registered yet? Has there been any guidance on that?
Generally speaking, obviously, it's a good idea to register the LPA as soon as it's made. But the OPG has confirmed that it will continue to register LPAs whilst its service is being affected by COVID-19. They are expecting some delays, but it is aiming to register within 40 days. So if you haven't registered, they are still accepting registrations, and it is good advice to run away and do that as soon as possible.
Yeah. And I suppose another issue which arises, follows on really from our question about witnessing, is the issue of getting an appropriate certificate provider in relation to the LPA. I know that there's been some guidance from the Law Society, which, contrary to previous understanding, suggests that a solicitor who's prepared the LPA can act as a certificate provider. It seems to me that it would remain ideal that the person doing that would be an independent person qualifying under the relevant rules. I'm not sure if it's possible for the certificate to be given following a video conference. Is there any requirements that it is done in the presence of the person making the LPA?
I mean, ordinarily the certificate would be given following a face-to-face meeting, but it may be possible to use a video call in these circumstances, particularly if the instructions have already been given in a meeting. There's no sort of specific requirement that has to be done in physical presence, but obviously the usual considerations apply. So the certificate provider has to be able to confirm that the donor understands the scope and purpose of the LPA, that there's no fraud or undue pressure being used to influence the donor to make the LPA, and so on. And I think all of your observations earlier as to the difficulties of fraud, of ascertaining whether there's fraud or undue influence over a video call, all of those apply equally here. So if people are social distancing in the same house as the person that may be exerting the pressure, then those problems arise equally here.
And I suppose if one does have that kind of concern, either as a solicitor who's drawn up the LPA or as a certificate provider, I suppose the other alternative, if the LPA hasn't been registered, would be to apply for a deputyship order from the Court of Protection.
Is the Court of Protection still open?
My understanding is the Court of Protection is still open, and it's endeavouring to deal with cases that are being considered urgent. However, there's a sort of an intricate process whereby they're taken from the ordinary Court of Protection down to the family division, so I'm not quite sure how that operates in practice and whether things might get lost along the way. But I mean, do you see there really being any particular difficulties facing deputies in this period of time?
I mean, in practical terms, it's the same difficulties that we're all facing about how to carry out our responsibilities remotely. If that's matters like carrying out financial transactions, checking balances and investments, one hopes that the bulk of that sort of work can be done online, but then it may be that some decisions have to be postponed. In particular, the sorts of decisions like helping an incapacitated person to make a decision for themselves. If that person is unable to use the sort of electronic video conferencing software that would be necessary to communicate with them, then it may be that sort of work simply has to be postponed. I don't know if you've got any further thoughts.
No, I mean, I think deputies should be giving real thought as to what other services might be available to the patient during this period of lockdown. So, for example, are there local authority services which might be accessible? Are there any charities offering, say, for example, food supplies during this period? I think also deputies need to be aware that, as of yet, no lifting of the requirement that deputies' reports are filed annually on time. I think that the OPG is going to be particularly mindful of the difficulties that deputies might face in fulfilling those requirements at this time. But I think that realistically, what's going to have to happen is a practical approach whereby you liaise with the relevant officials at the OPG, and one will just have to see how their guidance plays out over the next couple of months. But I think there's no doubt that both attorneys under LPAs and deputies are going to face practical difficulties in not taking instructions, but facilitating the taking of decisions by incapacitated patients during this period.
That's really interesting. Thanks, Gregor. I think we will leave it there for today. In the notes to this podcast, we're going to put all of the relevant links for the bits and pieces of guidance that we've referred to. So thank you very much for joining us, and hope to see you next time.
Thank you.